let's get started. I know everybody's time is valuable, and we are really excited today to talk about AI and events with contracts. Firstly, I want to give a shout out to our great partners at Site, Florida and Caribbean chapter. Highly recommend for any planners on the call today. If you're not familiar with Site, it's a great organization that Hopskip is a big supporter of. We know a lot of our planners are members of that organization and tell us how valuable it is. So from like a community perspective and from a networking standpoint, we definitely encourage folks to give it a to give it a look because we hear awesome reviews, and we're excited today to have Site bring us AI and contracts with Legalese with the ladies. So thank you, Site. For those of you who might not be familiar with me, my name is Sean Whalen. I'm one of the co-founders and CEO of Hopskip. Hopskip's a platform that professional meeting and event planners use to source and contract hotels for their conferences, events, incentives. Today, I am super proud to be joined by two amazing attorneys in the industry, Barbara Dunn and Kelly Bagnall. I'll let them introduce themselves, but these are the two women that are going to be providing the guidance and the insights on what they're kind of seeing today in the world of contracts, specifically how AI is intertwining in the world of contracts. So I'm super excited. I'll let Barbara introduce herself, give a quick background.
Thanks so much, Sean. Welcome, everyone. Thank you so much to being with us, and thanks to the good folks at Site for sponsoring today's program along with Hopskip. We appreciate the support. It's a pleasure to be with you. I'm Barbara Dunn. I represent groups on all types of matters regarding meetings, events, and hotel contracts, convention centers, and the like. And I'm delighted to be here today along with Kelly Bagnall.
Thank you, Barbara. And I too want to throw out a thank you to Site for sponsoring us today. Kelly Bagnall, Holland & Knight. I am an attorney that represents hotels, management, and owners, both on all operational issues, which includes group contracts. I also handle not only the transactional side, but the litigation side. So some of the things we're talking about are the cause and effect. And so Barbara and I will say it trickles over into both sides of the practice. So we're thrilled to be here.
Thank you both. Before we jump into today's content, as always, we're going to make sure we're providing a disclaimer here. Everything today is completely general information and educational. This is not legal advice, so please always consult your own attorney. Today is just a discussion with two great attorneys in our industry. With that out of the way, before we dive in, we want to do a quick temperature check from the folks in the audience. How often are you using AI, if you're using AI, for event contracts? And specifically, the contracts we're talking about today is contracts with hotels, but we'd also be super interested to know if you're using AI in contracts outside of the venue contract. There should be a poll on the screen. It looks like results are coming in. Okay, so about 50% of you are saying on every single contract in some capacity. All right, so numbers are switching as we go live. It's looking like 50% now saying rarely, if ever. And then, all right, so starting to stabilize here. This is interesting. We'll share these results too when we send out, which will be next week, a recording of the webinar. So results will be shared as well, but just to make sure everybody knows who attended or did not attend but registered, you'll get a recording. All right, so the results are in. It is 60-ish% rarely, if ever, I use AI for contracts. 25% only when we can't reach an agreement and new language is needed. and 14% is on every single contract in some capacity. All right, so we got a wide spectrum today of folks with experience using AI in contracts. Awesome. With that being said, let's jump into today's content. All right, Barbara, do you want to take it away?
Absolutely. Thank you so much for responding to the poll. And I'm delighted that sounds like the majority of you aren't really using it yet, perhaps in connection with your contracts. So this webinar is a great opportunity for us to share with you all of the concerns that we have about using AI in contracts. And hopefully then in doing so, when you may look to use AI in those contracts, you'll do so in that same light. So Kelly, I'll pass it over to you to kind of share the overarching legal concerns that you have, and then I can add to that.
Sure. So I do find the results of the poll fascinating. And as we get into this, some of our concerns are definitely going to weigh into perhaps the group that is rarely, if ever, using AI in the contract. But that, to Barbara's point, you're not using it yet. I think you're going to see that as a wave of the future. I will say, as a way to start, one of the favorite phrases that my AI partners use is that no AI model has ever been admitted to practice law. So that tells you their concern is that when you do searches and when you craft your prompts to ask AI for certain information and guidance, recognize that this is not a lawyer who's giving you the information, who is practicing law under a license, and that means a lot, because as you look at phrasing your prompts, when you're going to say, okay, give me a force majeure clause that addresses blah, that prompt that you're giving AI is going to be drawing from all sorts of sources of information, none of which may be a lawyer's thought process. And so just be mindful that what you're getting may not be the best legal answer to your questions. So, and phrasing prompts is a whole art form. I will tell you, we take hours of classes at the law firm on prompt phrasing to get the right answer and to get answers that are usable to start our analysis, not to end it. So I will just generally tell you that prompts obviously achieve the best, good prompts achieve the best output, but that is just output that's governed by what they can pull from and not necessarily the best legal minds. Barbara, want to talk about the bad paths you can get on?
Absolutely, and as we'll probably talk about a number of times during our session today, really distinguishing between open AI, so to speak, which would be publicly available platforms, large language or learning models that learn from the inputs that's provided, and what we'll refer to as closed AI, which would be customized enterprise versions of AI that may be used in your company or organizations that are locked down, so to speak. And we can dive a little bit more into that as well. But just to dovetail on what Kelly said, it's the prompts that are put in certainly that are going to drive the information that comes out. No question, AI is a extremely powerful tool in so many ways. We've all discovered that. And yet, that tool in the hands of someone who doesn't know how to use the tool can be dangerous. And I think that's really the point. And I know all of you, as you learn more, as you are, Kelly, as well, about AI, about prompts, about your system, thinking about how those tools will be used. But the tools are often only as good as your experience. And everyone listening in today has experience in the meetings and hospitality industry. And that experience is very powerful because it allows you to look at those outputs with that discerning eye. I think that's really important. In terms of what wrong paths it can take you, again, if someone's pulling an output and they don't understand a strategy, for example, you gave the force majeure clause, Kelly. If there's not an understanding about the difference between the grocery list of items that could happen and the standard of impact, you could wind up with a clause that have just one component. That could be a big problem if there's a dispute later on. So again, understanding the basics as you all are, I think is important as well. One other thing I want to jump in, probably hit this a couple of different times today, but just to talk about this, so many of the video platforms that we all use on a daily basis, including Zoom, including Teams, they have built in a variety of AI related functions, everything from recording to note taking and everything thereafter. A lot of those functions are set up as the default. So it's a concern from my standpoint on the group side that when I'm meeting with group to have a privileged attorney client discussion, or when I'm participating in a board meeting with the group or a committee meeting with the group, or even just the business meetings, any AI use of that recording, if that's being made, can absolutely be used in subsequent and discoverable in subsequent litigation involving topics. So it's critically important not only for each user individually to disable the kind of recording it can on the AI side with those meetings, but also the platform host, the host provider, setting up that meeting, making sure it's disabled, and then having a policy around recording, specifically that meetings typically are not recorded, so that you can have candid discussion. Make sure folks understand that they're not recording on their own devices. I know Kelly, as a litigator hat on for you, I know this anything that can be discoverable or potentially waive attorney-client privilege is incredibly problematic.
It is. And from, I'm going to kind of delve into. So your open AI, some of these platforms you don't know. So Barbara mentioned the note-taking functions, right? So if you're having a conversation with the other side and you've enabled that note-taking function, that could be it could be completely an open AI function that is downloading essentially those notes into a forum that is open AI that you did not intend it. And if you're using someone else's platform, i.e. their Zoom, and they've enabled something that you were unfamiliar with, you might have an unforeseen consequence there. Most rules, if you will, and we're going to get into the use rules and regulations and things like that, prevent most companies from using any kind of open AI system. Now, whether or not, I mean, that's the rule that's stated, but that may not be what's being implemented because of a lack of knowledge or a change in those platforms. So always be mindful. You don't want to ever waive your attorney-client privilege, i.e. your communications with your attorney, but your attorneys also don't want to ever waive, and it's a higher standard, their work product privilege. So when they're asking questions, they're going back and they're formulating their clauses and their responses and what their thoughts are with regard to that clause. You want to be particularly careful. So we're just sharing with you that even if you think you're in a closed system, when you jump onto a Zoom or something called that someone else set up, you may not know what the structure is of their system, and you've already had a problem arise because of it. And I know that, Barbara, when we come back to the risk of these tools, you can certainly dovetail on what you've already said as far as how risky those can be.
Absolutely. And again, I think, as we talk about this more, it's awareness building within your own organization, and will specifically focus on policy development as well, or things that you could discuss internally to initiate the discussions. Kelly, I know of particular concern. We've talked about generally legal concerns, but confidentiality really becomes among the most critical concerns, even in a use of a closed AI system, if there's not a good understanding of how that system might use that information that's being provided and ultimately where it's saved and stored. So I'll let you lead the discussion on the confidentiality.
So most of you have either you have companies that you work for that require the other party to the transaction to sign a robust NDA, or you've signed one, right? Or there's a confidentiality clause in the underlying agreement, or there's even beyond that, there could just be an underlying expectation of confidentiality. You have a lot of obligations relative to those confidentiality provisions that you are putting in play if you are using any kind of AI that could violate those provisions. So one of the sayings that's most often used in the legal world about AI is that if you aren't paying for it, then you are the product. You're providing the product that they're going to use and manipulate for other people. And so you become the product. And so these enterprise versions can be designed of AI can be designed to protect you fully, and so that you don't violate your NDAs, your confidentiality provisions, of things of that nature when you upload that information into those systems. If you're just using those systems to, for example, run a compare of one hotel's form against another hotel's form, that still needs to be a closed system, because both of those contracts have confidentiality provisions in them. And those hoteliers expect those negotiations to be confidential. But you can, in a closed system, run the compare to see, for example, why one person's force majeure clause, we keep beating on force majeure clauses, is different from another venue's force majeure clauses, and then try to mold whatever you want to in your negotiations. But the cost of protecting this information on a confidential confidentiality level, is really minor. There is no barrier entry. For example, there are some closed systems which allow you to fully retain, train, or store these items that you upload into AI on a purely confidential basis, can be as low as $25 a month. So there is absolutely no reason in my mind that you would use an open system for any analysis of any contract language, because of the fact of the risk in relation to the confidentiality concerns. Barbara, what did I miss?
No, I think that's a good point, Kelly. And I think just raising on the question about our use of today, our term closed system.
Yeah.
Typically, these are systems, AI systems, that are subscription based, where you sign up. And of course, it's all going to depend on the terms and conditions that you want to ask that provider. But specifically with regard to providing confidential information, how is that locked down? Making sure that information is not used to train a larger model and so forth. Those are going to be some critical questions to ask before you would sign up for a closed system. And, again, I know a lot of these could be custom built, but a lot of these might just be subscription based. And let's distinguish one other thing. I think if you're using an open AI, even, and I've heard folks refer to, the setting of an incognito search, is that going to make it better or protect it? I think the answer is no, if it's still an open AI, if it's still a large model, it learns from others and so forth. So I think that's going to be your initial criteria going into it. Now, specifically on confidential information, when we talk about meetings and events, we talk about a group on the group side, group having access to a lot of data. Beyond the contracts would be attendee registrant data, exhibitor data, etc. All of that, again, AI could be tremendously helpful in running reports and analysis and so forth. But if any of that information is fed into a system that is not protected on confidentiality, in addition to potentially running into a breach of confidentiality provisions and contracts that we've already committed to, we, the group, could also be in breach of violation of an individual's rights to their own personal data. And we have many states have laws regarding protection of personal data for their residents. We know countries throughout the European Union and others have laws protecting that too. So I caution it to say that in addition to breaching non-disclosure agreements, we potentially breach data provisions. So we definitely, from the organization's perspective, the organization itself, and any of the vendors that are on your so-called food chain for your event, housing, registration, etc. Everybody along that food chain, we should understand, and we'll talk a little bit more, I know about this, Kelly, in a little bit, how they are using AI, what systems they're using, and most importantly, flagging in proverbial pink neon flashing lights, not to feed in confidential data unless we vetted, right? We know it's a protected system. Anything but that really lends its hand to the potential of liability to the organization. And I know on the hotel side, you mentioned, Kelly, the hotel contracts, certainly when it comes to not only confidentiality restrictions or protections, but privacy data protections, that becomes critically important. I know on the hotel side as they're receiving it. So I think that's another example, again, along the so-called food chain of events, where this issue becomes particularly important.
So I'm muting and unmuting to see if we can help some of the sound issues. I agree with everything Barbara said. One thing I'll say on this slide before we move on. Recently, it was reported that shared chats or texts through Claude have been searchable on Google. So just to show you, if you don't understand what is feeding into what, you could have a really bad consequence to that. And I think all of the things that Barbara said feed into that as well. So go on to the next slide and we'll see if we can address AI. So Barbara, why don't you give us a start here with the clauses?
Thanks, Kelly. So again, going back to what I'm describing as the so-called food chain for a meeting and event, everyone on that food chain, I think we can't put blinders on. We have to assume that they may be using AI in some capacity. Obviously, you first want to ask if they're using AI. If they are, what type of system they're using and how it's being used. And that can be done in a request for proposal process as well. So again, not necessarily on the hotel side, RFPs, but perhaps more again, housing, registration, event tech, et cetera. How do they use AI? Assuming the way they use it is acceptable to the group, then on that, when we're talking about going to contract with that vendor, putting in language around the AI is important. So first, how do we define AI? In the contract, you can define it, you should define it very broadly, but specifically if the group understands this to be a closed system, so to speak, that's the vendor is using, we want to make sure it's defined as such. We want to talk about how the vendor can use AI. Maybe it's to generate data, et cetera, and then how they cannot use AI. So again, whether it's ultimately work product output, again, depending on the nature of the relationship, you'll want to set up those parameters. Always finding out where's the human in the room, so to speak. Where is the human oversight? How does that human oversight come into play, for example, when it comes to the AI output? That's going to be important for the group as well. Who owns the intellectual property? Going back to the outputs, the one thing the Copyright Office has made clear is that an output, which is 100% generated by AI, would not be subject or benefit from the protections of copyright. However, it's unclear after 100% where that scale tips. So, for example, if 70% of the article was written by a member of the group staff and 30% massaged by AI, so forth, is that protectable? So I raise this just to say ownership of the output becomes important. We want to know about it. We want, again, AI use to be disclosed. Importantly, if the vendor's using AI, we just want to keep records of how AI was used because there's, again, a lot of potential here. If there's a problem later on, we want to understand what the workflow process was and how it was used. And then at the end in that clause, and this is true probably with any vendor contract, when it comes to handling or processing of data, we want to make sure we understand what happens there's a breach. So similarly, if the AI is used and fed data in a way that the group is comfortable with, we understand what the vendor will do at a breach setting. Kelly, those are some things that when I look at contracts with clients where I know AI may be used, I look for. From the hotel's perspective, how do those align with what the hotel would be looking for?
So to date, what I've seen in most hotelier agreements is just a pure confidentiality clause that governs the totality of the relationship between the parties and the agreement itself. There are some clauses that I've crafted and that others in the industry have crafted to start adding as AI as it has become known that some of the documents and some of the contracts that hotels tend to deem as confidential are being fed through an open AI system. And so I think as an industry, we're going to start seeing more of those AI specific clauses. And I do want to point out, no matter how good the clause is that you craft, right? No matter how good you have and how well you have attached each of these items that Barbara has mentioned and crafted that perfect clause, it is only as good as the fact that they've disseminated the information to all those people that touch on that agreement or that relationship, and they all understand the parameters of the use. It's not good if there's not open communication within the organization that it's agreed to that clause about what the parameters are. That's where you have the room for error to have happened. So I think we've touched on what most of those clauses would include, and I think in the future you're going to start seeing more of them.
Yeah, I agree, Kelly, and I think, this begs the question about what should organizations be doing internally when it comes to discussions and policies and guidelines around AI use. So, as you can see, there's some, guardrails that need to be put in place. So, first, within the organization, again, I would say no, none of us want to bury our heads in the sand. We should talk to our teams and our colleagues internally and ask how AI is being used. And if it's being used in a way that it shouldn't be, let's talk about it in a defensive way. Because the goal is to shepherd, to educate the group to say, here's how we can use AI, for example, in the meetings department of our group. Here's the AI we should use. This is why we should use this AI. This is how you should use this AI. Let's talk about other use cases that might be acceptable. So understanding what the approved tools are, understanding what the appropriate purposes is important, re-emphasizing confidentiality and privacy. And just to dovetail on this point, I'll say we talked specifically about data, personal data, for example. We talked about terms of contracts that might be confidential. The definition of confidential and even proprietary data, so data that has a financial value. In other words, it's very broad. And so I would take the position, conservatively speaking, that really any information that the group's going to have, whether it's the template, whether it's the data, any of that, is assume it's confidential and act accordingly. I think that's a safe bet. Understanding it's broader than that. It isn't just as I often joke, the secret sauce recipe. That's the only thing that's confidential. Everybody knows that a force majeure clause should have X, or we got this rate and that should have Y. Again, I think you want to make sure you treat everything as confidential. Making sure, again, there's a human in the room. What's the human accountability? So, for example, if you had AI develop a request for a proposal or an RFP for an upcoming event, is the human in the room reviewing it before it gets sent out? Hopefully the answer to that is yes. Verifying for accuracy, et cetera. Not letting AI solely generate an RFP and then send it out without a human oversight. That would be a concern as well. Again, record keeping with guidelines become important so the staff understands what outputs were provided by AI and how that was used. And most systems, again, should make this pretty easy to save results of an AI query or search. And then ultimately, ongoing training and oversight. I mean, Kelly, you gave the example in your firm, ongoing training around it, just so folks understand. Things are changing literally minute by minute here. Understanding what's out there, understanding how it could be used, and maybe how it could be abused. Those are things, Kelly, when I'm talking with a group and kind of helping to establish guidelines and policies, it's more about education around the appropriate tools and how they should and shouldn't be used than it is, I think, an absolute, don't use it ever, period, because I think that becomes a dangerous assumption and dangerous directive, really.
Completely agree. And as lawyers, y'all have probably read some of the cases where many lawyers have been popped with sanctions and their clients have been have really bad outcomes in lawsuits because their counsel used AI without checking it, right? And so as a lawyer, what with AI and how we use it is really tight, right? It's really just a tool in a quiver of tools that help us, but it doesn't replace independent thought and evaluation and analysis. So when you're looking at your internal guidelines or creating them for the first time, much like you can imagine they are in the lawyer tools, I mean, we have consequences in ours for abusing and misuse of AI. And there should be some consequences because they need to be serious. At least that's my opinion. But Barbara may be a little more thought provoking as far as the carrot versus the stick. But the stick has always worked with me, so that's why I see it as being predominant and favorable component of these rules and regulations. So
Would you say
the
that,
next,
sorry,
go
Kelly, I
ahead.
have one follow-up question on this. For someone that, or an organization that has zero AI policy today, what are the core three things that we need to make sure we're thinking about including? I know that we have like 10 or 12 guidelines on here, but what, just as a takeaway from this slide, what are those three core things, would you say?
Well, mine would be, and Barbara, please, mine would be you can't use OpenAI because there's just no way to know that what's happening to your data if you're using OpenAI. And
Right.
two, that it doesn't take I'm only going to give you two. It does not take the place of independent analysis. Period. End of story. You have to sit down, no matter what is out within a OpenAI. And to go back to our example, it may spit out a great force majeure clause, but what it doesn't tell you is there's 5 other places in that contract because of how you've changed that force majeure clause. You need to fix the contract so it all gets read together. And so if you're just generating something and slapping it into a document and it's being accepted, you're probably missing so much. Barbara?
Yeah, I would say, for my 3 points would be what the approve AI tool is for the organization, therefore reading between the line what the tools aren't, specifically, as you note, Kelly, the open AI components. Second, what's the permitted use of AI? Again, read between the lines what's not permitted, including feeding confidential data. And then the third would be the human in the room. Just as you said, Kelly, the oversight, the feedback, where does a human in the room come into the process? Those would be the 3 core components, Sean. I would say if a group is thinking about this, developing policy and so forth, and even if there's not a policy around that, those 3 things should be the conversation at your next brown bag lunch or coffee chat. Because those are things, if we're not talking, that is our teams, our colleagues are not talking about them, they're likely being used and likely not in a way that's going to support the best scenario for the group.
Well said. What follow-up question to that? Who are you guys from your seats seeing with inside of organizations kind of owning this, like policy creation or kind of driving this from within? Is it legal? Is it ops? Is it like the planner typically trying to enforce this AI policy when it comes to AI and events?
From my perspective, it typically originates in
Yeah.
legal, at least to start. The technological end of it tends to lie with a CIO or in person that's handling the data input and output from your organization and the systems. But at least from my perspective, it typically starts with lawyers.
Yeah, I would agree with that from Kelly from the group side as well, starting with legal. I will say there's always a lot of pressure put on the IT folks within an organization. I use that term broadly to say, "Oh, here's the issue, fix it." And the fact is, the IT folks are wonderful at what they do, but they know their tech side. In an organization, let's use a large association, for example, you're going to have every department, membership, meetings, events, publications, you name it, finance, that's going to come in contact with AI. So, what a lot of organizations do, and I think this is a great strategy for a company, it doesn't matter really, is a bit of an interdisciplinary group, representatives from different groups that get together to talk about how AI is used within their departments, sectors, et cetera, to help build a policy around it. And then if to the extent there are settings for technology or things like that, that gets flowed up to the tech team and certainly legal would be part of the oversight. But I think it's having those larger conversations, Sean, within an organization that become important, larger in the sense that you have all different sectors represented in the conversation. I would include legal in the conversation, even just to listen in, to just give some parameters. And then the folks that might be looking at closed AI systems understand the use issues so that when they go to look for a request for proposal, look at vendors, due diligence on vendors, they understand how the organization will use it. And hopefully then in that way, you'll get an closed AI system that would work for the group.
That, yeah, extremely important. Making sure too, the vendors are providing that kind of information up front during the evaluation stage is super critical when you're comparing. So I appreciate both of those responses. And we got a question from the group as well on this. Vilma is curious on, does AI own the rights to an image it creates slash generates, for example, like a logo or an event theme image?
So I'll just start on this and say that, if it's 100% created by AI, the answer is likely no. And of course, the group wants to own. I mean, you hire a graphic artist or you put it in AI, you want to own, right, the branding around your events. So making sure always that anyone who creates that assigns their rights to you is important, that the group owns it. In an AI system, 100% generated, not necessarily going to be protectable. So I caution, groups. I will also caution groups to really be careful about photos and other things they use in connection with their events. There are a lot now. Now AI can be used to troll the internet, and I've had a number of clients be hit with, they might have used a picture from a location, thinking it was okay to use without permission or a license from the owner of the photo, and then later get hit with a claim by the owner of the photo. So I think this question, Sean, raises issue not only in terms of IP ownership of the IP output, but also just generally cautionary tale around all types of IP that's used for meetings and events. Again, logos, photos. Kelly, I know the hotels probably are struggling with this issue too, as that maybe they get pushed toward different branding and narratives and marketing and promotion as well.
Yeah, the hotels are subject to claims by folks all the time, just like you mentioned before, that someone didn't have the right to use a photo. And because of the breadth and the severity of some of those lawsuits, because typically things have already been put in place and it's already going to cost a fortune to undo them, right? We tend to take very aggressive approaches to make sure that we own everything that we're putting out there. And so consequently, using I can't imagine, and this is not what I do for my hotel clients, so I'm guessing, but I can't imagine that we would ever use anything created through AI in a formal fashion. We would make sure we actually had ownership rights to every single thing we put out there in the market attributable to our flag or our hotels.
Yeah, that's certainly, I think, certainly best case as well. And I know a follow-up question that came in is, would that analysis change if this was done in a closed AI? And again, I think if we're talking about 100% generated, if I just went into a closed AI and I said, create a conference logo for next year, I gave it nothing, it may or may not draw upon logos the organization has used in the past. If I fed it to say, you know what, we used these logos 3 years ago, we like the color, we like the style, whatever it is, maybe there's an argument there that, again, it wasn't 100% created by AI. But this raises, the issue again. I think anything the organization would invest in or put resources behind, you want to make sure you own it, lock, stock, and barrel, or that you have a license, which is the fancy word for permission, like a permission slip, if you will, to use it. Those are the two bases. So in the situations when I give clients that have been, a challenge for use of a photo, for example, I will ask the client, did you own that picture? Do you have the rights to the picture? Or do you have a permission slip, so to speak, a license to use that photo? If you don't have either of those things, we're likely in a weak position to argue that we, did not violate someone's copyright or infringe on someone's copyright. That becomes a big issue. And again, I go back and say, thinking about design and layout of websites and everything else that goes into meetings and events, we know the IP is a very important component. And so this issue, I think, just emphasizing and having the conversations internally around this issue, use case. Is it okay use case wise? to ask AI to 100% generate, the program for my event or so forth. That's the kind of questions I think the groups should talk about, and obviously involve legal too.
Well said.
And I'm just saying, one lawsuit involving something they say you don't have the right to could knock out profits for years. So you don't want to play fast and loose on that issue.
On that topic of third-party systems slash AI tools, in terms of like reliability and accuracy, being able to take that information and run with it, where are we right now from like a maturity standpoint or a confidence standpoint from your seat, Kelly? Like, I know we spoke about earlier some of our concerns. I know we spoke about the confidentiality piece, but in general, are you thinking that this is the future when it comes to AI and contracts? Like, how reliable are they today, and where do you think they're going tomorrow?
Probably asking a lawyer that is, I don't see that third-party tools replace lawyers.
Right.
I mean, there's a lot of discussion in the industry that AI is going to replace all lawyers. It can't. It won't, because of the fact the thought process is required and the dive into what is the basis of the language being put into the clause that AI may generate. Is it accurate? Is it founded in law? Is it correct for that state? Because every state has a nuance. I think the tools are nice to give you guidance, to maybe some places to look, maybe a backstop for an analysis you've already done as a lawyer. Do I think they replace lawyers on creating language? No, I just don't. Uh, Barbara, your thoughts on that?
Yes, I mean, I would say, on the question of how reliable or how effective are they, I think I'll give the a two-word answer that annoys everyone, which is it depends.
Depends.
And it depends on a couple things. I mean, certainly the tool itself, and I know the tools can vary, and some are more advanced than others, learn more than others. So, I'll let that kind of set aside. But also in the hands of the user, right? We talked, Kelly, about the prompts and how important they are to put the prompt in appropriately. But the output becomes important in the hands of the user. How is the output used? So, for example, it's only helpful in the eyes of a user that really understands the nuance of a force majeure clause, that can discern whether this is practical. To your point, Kelly, whether it complies with a state law, whether you have a specific experience on case law on this issue, or your organization has previously negotiated an item with this brand or this management company and so forth. All of those nuances have to be present, and I think that's where the tools, Sean, fall short, because they'll never replace, to Kelly's point, the institutional knowledge, education, professional development that everyone who's involved in the industry has, and we don't want that to do that. But again, going back to Kelly's point, is it a helpful first start? Sure. Is it, I've equated this sometimes as the AI is like, for those of us used to work in an office environment, the equivalent of leaning over someone's cubicle and saying, "Hey, do you have any idea about this thing?" Right? Or to Kelly's point as well, on the backstop, "Hey, can you take a final look at that? Am I missing some?" That type of thing. I like to think of the relationship perhaps with AI in that way. Again, it's going to vary in every organization. And, Sean, before I turn back over to you, I wanted to answer, or respond to at least my perspective, and have Kelly do the same on the question that's come in the chat, which is, um, does a confidentiality clause cover AI use or abuse? So, for example, when we talk about non-disclosure agreements or NDAs, often NDAs give a very broad definition for what's confidential information, and it gives a very broad restriction on use of that confidential information. So, unless there's a specific exception or so-called carve out for allowing a use of AI, if you feed what that defines as confidential information into AI, even arguably in a closed system, you might be violating that agreement. So it's just going to depend on the clause, and it's going to depend on the system. This is why a lot of vendors in their contracts nowadays, they'll have a confidentiality clause as it might relate to data that's exchanged, but they may also have an AI clause that we were talking about earlier, which in other words would allow certain use of confidential information for limited purposes, again, with appropriate restrictions and so forth. So I think the key is that any of you that are subject to a broad confidentiality restriction, before you put any of that data about that meeting or event into AI, go back and look at that underlying contract, see what the restrictions are, see if you've had a conversation with that other side to gain approval to use AI for that meeting. Because I think that goes back, Kelly, to the point that we made earlier about the tie-in with a confidential. These confidentiality clauses are typically very robust, is my experience, Kelly. And so I think it's safe to say that use in any other way that's limited is going to be likely, arguably, a breach of that clause.
And so to summarize that, if it doesn't say that confidential, including AI, it still probably covers it because it's written so broadly. You don't have to use the words AI to either have a carve out or an inclusion. It's probably the words on the page already cover it.
Good. We got some thumbs up from the audience. I think everyone enjoyed that one. Another question that I've heard time and time again, and looks like it actually came up in this webinar too, is okay, we understand feeding OpenAI confidential information or contracts can bring on some risks. But what happens if I do that by mistake, let's say, or that happens? What do I do now?
I'll jump in to start. So I had a long conversation with our a team here at the firm to say, is there any way you can claw it back once it's out there? And resounding, the answer was no. So that being said, you're going to go back to whatever rules and regulations you created, the tools that Barbara gave you earlier. There's likely going to be, and there should be, a what happens if tool that's going to give you a protocol or an information tree on who you notify. Separately, Barbara and I discussed this, and obviously, if it was information that the client is going to be super unhappy is out there in an open AI system, you're going to craft a response to that client. You're going to perhaps notify your insurance carrier, and on that note, there may or may not be insurance to cover that type of breach. Right now, the resounding philosophy is it would sit in an E&O policy, or an emission policy. As you can imagine, carriers are looking at whether or not those are going to be covered claims. So just don't think, well, we've got insurance, because you may not. And that may be a very quickly evolving field, since it's a quickly evolving field of AI. So that what we know today may be different than what we know in 2 months. So, Barbara, anything to add on that?
Oh, I would just echo that, and say that, cyber liability insurance, as it's often broadly referred to, is a critical component of any organization's insurance package. So always wanting to look at it. This will often cover a number of situations, including data breach, which obviously becomes important. But the risk assessment, many carriers will help in the front end as you go to apply for the insurance or on a regular basis, help to undertake a risk assessment area, with the group. So again, we're obviously trying to troubleshoot any problems before they happen. And I think that's a good strategy. But I agree with you, Kelly. And often I'll joke about this, as much as I say insurance is absolutely an important component of risk management for meetings and events. To say it's not the stopgap, or to say you can't just say, well, I'll do it anyway because we have insurance, right? Because insurance, often the goal is to say how it's not covered. Something is not covered. And that's not saying that, again, to discount any value that the insurance brings. It's just to say that the most important thing you can look at in your insurance policies, no matter what type of policy, is the exclusions page. Because if there's anything on the exclusions page that you need coverage for, you need to have the conversation. You need to see if you can get an endorsement or coverage for that particular item. So I think, to your point, Kelly, as the AI field, if you will, expands, I think we're going to see the insurance carriers respond. But, going back to the overall question, Sean, this is a crisis management issue, right? An accidental feeding into OpenAI becomes a bit of a crisis. And the groups here, again, on the policy front, guidelines front, we talked about earlier, Sean, the three things, if you will, we should be having conversations about what happens, what if, right? What if we're all understand what the rule of the road is, but we break it anyway? And Kelly, we talked earlier about the stick and the carrot, which I absolutely would understand and agree. But risk management wise, what do we do next? Who do we call? Where do we go to? Again, it's similar to when we talk about the importance of crisis management and planning. Certainly, when it comes to the potential of the AI, this so-called breach, if you will, on the AI front, I think that becomes a critical thing. Obviously, the goal is to avoid it from happening in the first place. So I think avoiding use of OpenAI in a work context is a very broad statement, might be a safe thing to do just to have the closed AI protection. But the oops moments, panic moments, if you've had those and you worry, who do we report those to, right? How is it addressed? That's a key component. And I think, Kelly, whether insurance, other carriers, legal need to be notified, it's going to just depend on the situation. But I think often just building education among the staff as to what would be a problem, and knowing about it, like every problem, sooner than later, allows opportunities to the extent, if there is to be a clawback, if there could be, if there can't be, we understand what that looks like, but documenting it becomes important. And by the way, the insurance companies are going to want the groups to document too. So here again, having a policy, understanding you've documented things internally will become important if coverage is later an issue. Will be showing that the group acted prudently, and that definitely becomes an important element of the issue.
A lot of sense. Another question that just kind of popped up, Barbara, that I'd love your take on. When, well, let me put it this way. What is a key question to ask in an RFP, specifically for a hotel or DMO, about the use of AI?
So I would say key question, and there'd probably be a series of questions. Just to, the key question: does the organization use AI in its operations? I think that's a very broad question with a hotel or group. If yes,
What
how
is it?
so? If yes, what type of AI is it? And then I think you're drilling down further. But I think those would probably be, Sean, the threshold questions to ask. Similarly, an organization, should be prepared when you are asked that question
Right.
to have those responses. And here again, that goes back to the policy, or guidelines, which can be helpful as well. Yes, we use AI for these use cases. We use this type of AI, necessarily getting all the particulars, but just indicating it's the so-called closed, et cetera. And that way you're able to quickly communicate again how it's used, because I think you're going to have more folks asking these questions. And I agree. And thanks, Joan, for raising the issue that we should put this as a question in an RFP, just a standard question you might ask. Again, part of a due diligence with your vendors for meetings and events.
Yeah, it makes a lot of sense, and it's something we're actually thinking about as we speak at Hopskip, about including that as just like a standard default, or we're giving the planners at least an option to include that as a standard default. Kelly, how often are you seeing that from your clients, or how often are your clients seeing that in RFPs today, that question specifically?
I'm assuming not very often, because they are not rising to my attention to review at an RFP phase. But
Right.
I will tell you that all of my institutional clients have protocols and procedures, and they wouldn't probably answer the question in the way that Barbara just asked it. They would refer back that we have policies and procedures in place.
Well said. And with that, we are just about at time. So I would like to thank, firstly, Barbara and Kelly again for another excellent educational webinar. We really, really appreciate all of your knowledge. Also like to thank our sponsor today, Site. And site is having a networking event at the new stadium, Miami's newest stadium, and it is on September 14th. We sent out a link for any folks that are in Florida. Check it out. Great organization. And we look forward to the next one, guys. Please feel free to drop any feedback. Again, we do these quarterly. Appreciate everybody's engagement.